Mr. Henderson, you may proceed.
Ladies and gentlemen, you've been attending, sitting here, listening to all the proof in the case. The judge has told you that the lawyer's arguments or whatever we say is not evidence. We're trying to present our position on the case based on the law and evidence that's been presented. But in doing so, you know that this week has been the trial of Tremaine Wilbourn. But I will tell you that that's not the only trial here. It's also the trial of Sean Bolton. And I don't say that to garner any sympathy or prejudice or bias, because as the court has told you, we talked about it in one hour, in your instructions, you cannot base any verdict on sympathy or bias. It has to be based on the evidence that you heard in the law that the court has given you. But having said that, isn't that what this is about? What happened on August 1st, 2015 with Tremaine Wilbourn and Sean Bolton? It's the state's burden of proof beyond a reasonable doubt to prove every element of the offenses charged. That would be first-degree murder, carjacking, deploying firearm, doing the commission of a dangerous felony, and convicted felon in possession of a firearm. All of those things have elements. And I submit to you through the witnesses and what's been presented, the state has carried that burden. And I'm not going to go over everything, but I am going to touch on a few things. Now, one of the things that was questioned was about Ortega Jones. You heard defense counsel say that was the first time you heard anything about any backing up and shooting. But if you recall, during the course of that testimony, there was a break in which we had an opportunity to listen or receive a document in which the investigator had spoken to Mr. Jones. And in that, it said from their investigator that he had backed up and shot. So that wasn't the first time. And you heard that in this trial. And I submit to you that you're asked to believe now that the state has not carried its burden when you talk about first-degree murder, when you talk about an unlawful, intentional, premeditated killing. Those are the elements of first-degree murder. The court has already read to you that you read along with it. So what is there here to show you that there was a first-degree murder, that there was premeditation? Remember, there is no specific time for premeditation. The court has explained that to you. It's about time to have reflection and judgment, whether that's a second or whether that's a day or whatever the time period is. And I want you to review the facts in your mind about what happened. When Tremaine Wilbourn rode out with Little Dave, David Lanier, and was there in that car, and David Lanier took off running, Sean Bolton shined the flashlight in the car. What was it that made Tremaine Wilbourn's situation different from David Lanier's? What did he have that was different? And we all know what that was. He knew he was armed. He knew he had a loaded 9mm gun on him. He knew that. Now, whether or not what Officer Bolton said, I think what the witnesses say, they didn't hear Officer Bolton say anything. Not that he didn't say anything, they couldn't hear, they didn't hear. For whatever reason. But he knew he had a gun on him. He had a loaded 9mm on him. Now I ask you, did he panic? And you heard the testimony of people like Marquise Wright, who told you he heard a scuffle and then he saw the defendant push off Sean Bolton and shoot him. Tremaine Wilbourn could have left right at that moment. He made a choice not to. He made a choice not to leave after that first shot. Nothing was preventing him from leaving. That was his choice. But instead, as Officer Bolton is shot holding his face, he continues to shoot. And you heard the witnesses say he was shooting. You heard Special Agent Serena Braswell talk about the distance as well as to him either 4 or 5 feet. And he is shooting. And he is shooting. And he is shooting. To what end is he shooting? Is he shooting continually because he panicked? Or is he shooting because he intends to kill Sean Bolton? 11 shots, 8 of which struck the target, none of which struck and went through or into a vest. So what does that tell you? He's shooting him, he's going down, he's laying down, and he's shooting. What's the biggest center mass on a person? This area. He's shooting here, in between the vest, and here, and here, and here, and here. Everywhere the vest isn't. That's intentional. That's premeditation. That's first-degree murder. All the witnesses who got up here and spoke to you, all the people in that neighborhood who saw the shooting, whether it was Mr. Jones, whether it was Mr. Jones, whether it was Mr. Freeman, Marquise Wright, they heard the shots, they saw the push-off. But Tremaine Wilbourn made the conscious decision to stay there, not to conform to anything Officer Wilbourn was doing, but to resist what he was doing. And then to shoot him or at him 11 times. And then, and only then, did he leave. And he goes down the street, the carjacked Desert Island. And was he panicked? He wasn't panicked. He was trying to get away with murder. He needed to get away from that area right now. He wasn't driving, didn't have a car, and the first target that he ran into, he pulled that same gun out, put it to the back of Desert Ivor's neck, and threatened him is what he did. Scared him. And you can infer from what he said, I shot the police. I don't have no trouble shooting you. You better give me this car. Of course, Simon did just that, gave him the keys and he left. And where did the car ended up going? The car ended up at Mr. Wilbourn's girlfriend's place. Are these the actions of someone who's panicking, or are these the action of someone who is trying to get away with first-degree murder? You talk about common sense. That's all this case is. And I agree with one thing. There's no question about who did it, when they did it, where they did it, how they did it. And we don't know what was in Tremaine Wilbourn's mind, but we know what he did. And we can infer from what he did what his intentions were. And if you shoot a gun at a person 11 times, ladies and gentlemen, what is your intention? And you're shooting them all over their body after you've already disabled them. What is your intention? It is to kill them. That's exactly what Tremaine Wilbourn's intention was. There were no witnesses who said, I heard him say, hey, I got a gun on me. He didn't say any of that. None of the witnesses testified to that. Could have. And I submit to you, if Tremaine Wilbourn didn't intend to kill Officer Sean Bolton, what was he doing? What was he doing? And there's only one explanation for that. When you shoot a gun 11 times at an individual, you intend to kill him. And that's exactly what he did. And he did everything in his power to get away with it. From carjacking the car, and it wasn't until, as Marshal Owen Woods told you, that they were closing in on him, talking to all his friends, relatives, and it was just a matter of time. And yes, on that third day, on August the 3rd, he turned himself in before he was captured. Ladies and gentlemen, the judge is going to, after we finish, he's going to go over your verdict forms. And there's an order to the verdict forms. And it starts with the indicted charge, the highest charge. And I submit to you that if you have found that the state has proven that indicted charge, first-degree murder, carjacking, employment, and a convicted felon with a handgun, when you do those verdict forms, you're done. If you find that the state has proven that beyond a reasonable doubt. Now, there are lesser includeds in first-degree murder, and I submit to you that none of those apply in this case. We've talked about what first-degree murder is and the elements. Second-degree murder, the difference between second-degree murder and first-degree murder is the element of premeditation. But based on what you've heard, what I've talked about, I don't think that the evidence indicates that there's anything in this case but premeditation. I submit to you that the actions that Tremaine Wilbourn took are very consistent, couldn't be more consistent with anything but first-degree murder, premeditation. So there's no second-degree murder because there is premeditation. There's certainly no voluntary manslaughter. You heard the classic example early on in voir dire about the spouse who catches the other spouse and during the heat of passion commits a murder. We don't have that type of situation here. There's no adequate provocation to justify what Tremaine Wilbourn did to Officer Bolden. You'll also see on there reckless homicide. So what is that? It says homicide. Just an example. Person purchases a new weapon, and they just want to try it out to see how it works. Set up a target in their yard and they're just shooting at the target. No ill intent to hurt anybody. But after shooting at the target, they don't realize that they missed the target several times. And they hit someone else in another yard. No intent to hurt anyone, but the fact that you shoot is a reckless act, and someone dies as a result. That's not what we have here. This is not a reckless homicide or a criminally negligent homicide. It's November now, holiday season is coming up. And let's say Grandpa is having something at his house. He decides he's going to go hunting because it's getting close to Thanksgiving. And he's cleaning his gun. It's about 2 o'clock in the morning because he's going to get up early and go hunting. He accidentally drops the gun in the house and goes off and topples his grandson or something's coming down the hall and shot and died. We know Grandfather didn't mean to do that. But the act he had was so negligent that is a criminally negligent homicide. We certainly don't have that. So my point is, ladies and gentlemen, the only murder that applies in this case is murder in the first degree. And if there's any grappling in your mind about premeditation, I would just like for you to consider this. This is not a loaded weapon. This is not a weapon that is in evidence. This is strictly for demonstration purposes.
In the approach. One of the members might be in break. Is that correct? Here we go. I'm going to stop for right now. Remember the court's instructions. You still cannot discuss the case amongst yourself or with anyone else. And as soon as you're ready to go back to work, let me know. Mr. Henderson will conclude his argument. You can call Deputy Smith, please. Thank you. Thank you, ladies and gentlemen. They must be seated. Ladies and gentlemen, Ms. Henderson is going to finish or conclude and resume his argument shortly. And what Ms. Henderson was telling you before the break is that there is a replica of a 9mm gun that he has for demonstrative purposes only. He's not indicating that this gun is used by Tremaine Wilbourn. Tremaine Wilbourn is not indicating to you that the gun is similar or was the same type used by Mr. Wilbourn. He's not suggesting any of that at all. This has been done for the demonstrative purposes only. Lawyers are allowed to use props for arguments. Mr. Henderson, you may proceed.
As I was stating, if there is an issue in your mind at all about premeditation, and after you're thinking about everything that the witnesses who were out there that night have said and have told you about what they saw and what they heard. And as I was coming up here earlier, as the judge indicated, this is a weapon. It is not a weapon that was involved in this case in any way. It's simply for demonstration purposes. As we talk about reflection and judgment, and we think about what the witnesses said, what the evidence has shown you, that there was an initial shot, and then there were 10 more shots.
Your objection, please. May we approach?
Yes, ma'am. You may proceed.
As I was speaking to you with regard to premeditation, and in view of what witnesses have said, like Marcus Wright and Ortega Jones, I was wanting you to consider shooting a weapon, a 9mm handgun, as the spent cartridge cases indicated, and that they all came from one gun, what that might be like. And I had indicated that there was a shot. And then there were 10 more shots. I submit to you that premeditation is not an issue. This is first-degree murder.
Thank you, Mr. Henderson.